In California, it's illegal to drive under the influence of alcohol or drugs. And those drugs can include painkillers such as Vicodin, Hydrocodone, Codeine, morphine, Percocet. All of these drugs are central nervous system depressants. And if you take enough, it can have the effect of slowing your reaction time, slowing your reflexes, slowing your mental processes, and interfering with your ability to drive a car safely. And if you get charged with DUI, a Vicodin, or one of these painkillers, and you're convicted, then you face really the same consequences that you would if you're convicted of DUI of alcohol. And that means probation, a DUI school, a license suspension, possible jail time. So it's very serious. And if you're charged, you want to do everything you can to fight the case and keep it off your record. And the good news is that many times that's possible. We find that these can be difficult cases for the prosecutor to prove, because the key is it's never enough for the prosecutor to show that you were driving and that you had one of these painkillers in your system. They have to show that you had so much of it in your system that you were impaired, that your ability to drive a motor vehicle safely was impaired. And that's not always the case, and that can be very difficult to prove. A lot of times you may have taken the painkiller and maybe are feeling slightly the effects of it, but you're still able to drive normally. A lot of people, in fact, who have taken these painkillers for years have a very high tolerance, and they're actually able to take a very high dose of Percocet or Hydrocodone or Norco and still have total possession of their mental and physical faculties. We see that all the time. Here at Schaus Law Group, we have had a great record of success over the years at defending clients who are charged with DUI of drugs and DUI of painkillers. One of the things that we do in every case is we reanalyze the blood or the urine that was taken. And we do this in a separate laboratory. And a lot of times we find that the sample was contaminated after it was collected, that it was improperly analyzed, that the crime lab got it wrong. And we can get those, in those situations, often get the blood or urine results thrown out of court or excluded from evidence. And we look at all of the evidence in the case, and we take the position that even if there were traces of the painkiller in our client's system, they were still able to drive a motor vehicle safely, that they weren't so intoxicated that their driving was impaired. And in taking this approach, we've been able to get many of these charges reduced or dismissed. So if you're in this situation where you've been charged with DUI of a painkiller like Vicodin or Norco or Percocet, I would say don't just throw in the towel and go and plead guilty. Come talk to us, sit down, let us look at the case, put it under a microscope, because it may well be possible in your case to get it dismissed and to keep it off your record.